That's the point.
So ultimately, it looks like more and more that the suit will have to be.
See, what he did was yeah.
Something like an assis veris, and if there is any dispute, that Telangana civil suit will have to be.
No, so can I just tell you how the sequence first? We got this plan, this plan is approved. He takes out an application which is disposed of on the same day as the approval of the plan, where he seeks exclusion of the trademark. Correct? There's no suit on this date. There's no suit on this date. He thereafter appeals. It's at that point of time, which I'll just give you the dates. It's at that point of time that the suit is thereafter instituted. Then he moves for an injunction in the suit. And that is declined because you can't be pursuing this remedy at two fora. That comes up all the way up to this court. So the suit, sorry.
For the moment, brother and I, we assume the highest.
Yeah.
You succeed in getting his application dismissed.
That's it.
Where do you stand in the teeth of these governments in the plan?
No, where do it will stand excluded, my lord. His application will stand rejected.
Rejected. Now
Yes.
he can't declare in the teeth of this disclaimer in the plan that you are the rightful owner.
No, but I am only today seeking his application to be dismissed as the NCLT did. That's all I can ask for today.
That's all you can ask.
What more can I ask for? What more can I ask for? I can only say that this is all malafide, and we will go into the RP's statements, etc., on his pleadings, etc., to say that once there's a moratorium, where is the question of the advocate on both sides saying that yes, I register and thereafter I consent?
But that's it for the civil code. Because
no, it's the dates are there. The dates are admitted. The moratorium, once the moratorium, IBC says moratorium comes in on a particular date, the asset can't move out. Once the asset can't move out, where's the question of registering with the trademark registry at that point of time? Then, so that's the way we look at it. So this application,
pushing off these findings.
yes.
And leaving the plan as it is.
A plan as it is, washing off these findings and leaving the plan as it is. Absolutely right. Absolutely right.
This is what we have understood.
Yeah.
Your endeavor today is to assail the NCLT order.
Correct.
And defend the NCLT.
That's absolutely right.
They went before the NCLT.
Correct.
Their plea was rejected.
Yes.
Which led your client to move an appeal.
No, my lord, their application was rejected, so they moved the appeal.
Sorry, they went in appeal and the appeal is allowed.
Yeah.
What we can do today is, because the suit is already pending, you can record your submissions.
Yeah.
You can record your submissions. And then leave it to the...
So, but these findings have to go, my lord. I'm going to show your lordship.
Completely uninfluenced by either the NCLT or the NCLAT.
All right, and no, but there's a third prong which I'll just indicate to you.
We permit you to raise all contentions.
Yeah.
Before the
appropriate forum.
Below, yes.
Yeah. So
and there is we will clarify that no finality is attached.
No, but it should be effaced, my lords, because I'm going to show your lordship that if it's
influence that this application in the teeth of this plan would have been entertained by the NCLT.
Yes.
Because
all right, fair enough. If your lordship
is approved, both the NCLT's finding, NCLAT's finding will not come in the way, and any title issue on the trademark Gloucester will be decided in an appropriate civil proceeding. We understand that there is one filed in Telangana in CS COS 43 of 2019. It will be adjudicated there.
There'll be one more. Sorry. Yes, there'll be one more dimension also, just for your consideration. There is also an application for, because your lordship knows that the purity of the register has to be maintained. So I have filed my objections with respect to his registration.
That will also be.
That will also have to be, and on that I will make a request for your lordships to have a time-bound program for that particular application to be disposed of.
Rectification of proceeding.
Yes, it's a rectification proceeding.
That will have to be also decided.
Also decided on the merits, but within some time-bound manner, because otherwise there'll be all proliferation of claims, counterclaims, etc.
This being the plan.
Yeah.
Even if we dismiss the application, there can't be a declaration in your favor.
No, they can't.
Question is, in the light of their non-challenge to the approval of the plan, they can't have this application post the approval, because at least the plan is post the approval. The application is post the approval, isn't it?
Yeah, the application was filed during the approval
During the
process, but was disposed of by a common order.
Common order.
Yes, which approved the plan and rejected their application.
But their challenge now is only on the
Their challenge and appeal was a limited appeal
to the application.
to the application
Not
rejection.
the approval.
No, not to the approval.
In view of that,
Yeah.
it is CS this 43 of 2019 will decide uninfluenced by NCLT and NCLT. That can't be. You can't go beyond that.
No, I will answer without once if the lordship asks me, not I will.
No. Yes. Not a deliberating.
Hey.
Where will it take us to?
Huh?
All the legal issues today, yes.
Still we can't declare.
What will happen in this court?
Can't declare.
I confidently said that nothing
That is like NCLT also. In the teeth of the governments in the plan, none of these findings of the NCLT also will be in relation to insolvency.
No, there is
Because you take it or leave it, 60 subsection 5 is in relation to insolvency.
no, there is a if the registration is not.
NCLT has declared that they have no right, their agreement is void. All this will have to be in the suit.
That 14(1)(b) point is there. No?
It will be a defense for you in the suit. That look, you can't, in the teeth of the moratorium, have got it registered.
Yes, yes.
And the suit will take it as a ground and declare it or not declare it if they have a legal answer. Subject to what the Bhava and Mr. Kumar have to say.
See, this is not right. No? It's application. 240 is already the break.
When you submitted the plan, your plan would have said with the trademark.
Yes, yes, that's what I read.
These disclaimers, no, must have got in later in the negotiation or deliberation. I think. So you wouldn't have put this disclaimer.
No, it was a revised, amended plan.
It's an
Which we
amended
put
plan.
it.
There is a mandate, it will not.
Bound to be because
Yeah.
you will want everything.
Yes.
So obviously then you settle for this amendment. Your clients.
Yes, yes, of course, brother, it's my plan.
You would have said, I am the owner of the trademark, 72 crores only mainly for the trademark. Why would I pay you this much? They would have said, no, we are not able to give you. We will now incorporate these disclaimers. You said, all right. You said, all right, and took it. But that doesn't foreclose you from agitating. These intricate issues which in a 65 summary proceeding cannot be gone into.
Correct. Just have a look at page 225.
That is why our appeal is here also without SLP.
Yes. I see.
Where our jurisdiction point, our SLP, counter SLP is there, along with this, where we have taken the issue, the jurisdiction point has been decided against me by the appellate tribunal. So I have come here to say, my lord, that
What is your application?
my SLP,
What
Your,
jurisdiction?
your 16, your originating proceeding in this proceeding is your application.
That's correct. My application under 65 was 60 subsection 5 was given. But I have always said that it can't be decided in the NCLT about this issue about the trademark.
So what was your prayer then?
No,
240, page
Your
240.
Lordship may see that, my lord. But I am going one step ahead. But apropos what is falling from my lord, I am not objecting to that at all. All that I am saying is that the jurisdiction point which your lordship just now, my lord, observed, I am only answering that I have also filed an SLP because that point has been held against me by the appellate tribunal.
What is held against you?
That, my lord, we said that the tribunal doesn't have this can't be decided in these pleadings.
What can't be decided?
Yes, the part about trademark and the asset, the ownership.
But you moved an application.
So I moved an application first also for that reason only before the NCLT, which was rejected. So I went in appellate tribunal said, no, we have the jurisdiction.
We need to understand.
Sorry.
You went before the NCLT.
Yes, my lord.
Saying what?
My lord, saying this,
Ah.
that I have a trademark which has been registered in 2010-15.
Correct.
Under a license from 1995, I have been using this
Ah.
from 1995.
So,
And that this point about this asset is mine,
Ah.
and this can't be the subject matter of the asset under the resolution plan. It should be excluded. My prayer says so, my lord, at page 240.
Correct.
So, my lord, that was rejected by the adjudicating authority, the NCLT. So, my lord, I went in appeal to the High Court, to the appellate tribunal, which, my lord, records this at page number 8. And, my lord, that this is my appeal about. So, my lord, it formulates 3 points. The first point is regarding jurisdiction, and they hold, no, we have the jurisdiction. So,
Probably what you.
to that
is,
extent, sorry.
If you are only excluding, no problem. But if you are going and ruling in favor, that is beyond jurisdiction.
Please, I'm much obliged for that, doctor. So that is how, my lord, my SLP is also there.
The issue is okay, but go ahead and declare no jurisdiction.
Please. So that is my SLP person. So in any case, my lord,
Challenge NCLT because NCLT,
to the facts and circumstances. I'm sorry, Justice Pardiwala doesn't have it. I'm so sorry. So sorry. 272 top, para 52.
Yes.
Having regard to the facts and circumstances and said above, we come to a legitimate conclusion that the application filed by GCL, that is me, is liable to be dismissed, holding that the trademark Gloucester is the asset of the corporate debtor. This is what, my lord, and at, my lord, the conclusion also at page 297 records this.
But they didn't carry out a corresponding amendment to the plan.
No. So and they of course never went to challenge in the appellate tribunal or anything otherwise.
This is NCLT's order.
This is the NCLT order. So I went, my lord, and that my argument is recorded, and then the jurisdiction point, my lord, is held against me.
Now look at page 240, please.
So
There was no scope for any.
my lord, the prayer in my IA before in under subsection 5 of section 60 before the adjudicating authority. For excluding.
You said it's not a property.
No, but
Either way, it could not have been said.
no, but look at I am just pointing out, this is his prayer. Just see the prayer. To pass an order thereby directing that any resolution plan, if approved by the honorable adjudicating authority, shall exclude the rights in the trademark Gloucester from the assets of the corporate debtor, including exclusion of trademark Gloucester from the corporate name of the corporate debtor, since the said trademark Gloucester is not a property and asset of the corporate debtor. So he asked specifically for a declaration that it is not my property. Now under 65. Now please go to 271. Look at 271, page 271 of NCLT's order. Just have a look at that. Just two paras. 52, my learned friend has read. Look at para 51. The third objection is that the registration of the trademark in the name of the applicant GCL is invalid because it was registered in the name of GCL in violation of section 14 of the IBC. The CP 61 of 2018 was admitted on 9th August by declaring a moratorium under section 14. The application for registration was submitted on 15 September 2018. The registrar, upon receipt of no objection from the transfer agents of GCL and CD, registered the trademark in the name of GCL on 17 September 2018. No doubt the registration by conferring title on the trademark owned by the CD is hit by 14(1)(b). Having regard to that, is what is discussed above, we do not find any illegality or irregularity or contravention on the part of the provisions of the code or applicable law and regulation in treating the trademark Gloucester as one of the valuable assets of the CD. And then in light of his prayer, they say in 52, having regard to the facts and circumstances of the above, we come to the legitimate conclusion that the application filed by GCL is liable to be dismissed, holding that the trademark Gloucester is an asset of the CD.
Now, taking off your RP's application for approval, what is the finding? The same.
It's approved.
No, what do
it's
they
part
say?
of the same common order.
What do they say?
No, this. Is on the same day.
Same.
Yeah. So if your lordship just sees,
Page 296, my lord, is
page
the penal order.
246, that's the title.
Yes, 296.
No, sorry, 246 or 290?
Operative is 290.
Yeah, 296 is operative directions.
That's the operative resolution plan is approved. That's all.
Order the resolution plan of Fort Gloucester so-and-so, which was approved with 73.21% voting shares hereby approved under the provisions of subsection 1 of section 31 of the IBC, which shall be binding on the corporator Fort Gloucester Industries Limited as employees, members, creditors, guarantors, the central government, any state government, or any local authority and other stakeholders. The clauses related to waiver sought for is not approved by this bench. The outstanding statutory dues, stamp duty, payable, etc. will be governed by the provisions of the respective act.
That's all.
And then please go, my lords, in the I. CAIB number 713 KB is dismissed, holding the trademark Gloucester is the asset of the CD No order as to cost. Your Lordship has that?
This.
This was the portion which was challenged in their limited or restricted appeal. So it was, in a sense, it's a common order.
So are you saying that the plan read with this order clears the trademark in your favor?
Yeah, that is, I mean, that's my primary position, that once this order, which is what I am hoping to persuade your Lordships to sustain, is says what it says. I can't go anything beyond this, my lords. It does it. Now, if this is to be made subject to some further order, etc., which is to be passed, because look what the NCLT had before it.
Has to be read with the order, which
Yeah.
means the disclaimer part is over now with this adjudication.
Yes, this adjudication inter se for the purpose of IBC is over. For the purpose of IBC.
So,
But there may be still some higher right. There may be some higher right on the basis of which X gets knocked, which may be adjudicated in a suit, may not be adjudicated in a suit.
IBC purpose, the plan has to be read with this
If
order.
the integrity of the plan deserves to be preserved, this is how the manner in which it is done. This section 14(1)(b) is clearly within the remit of the NCLT.
We have to go into the correctness of this.
Yes, this deserves to be sustained according to us. Yeah.
So then you place it.
Yes, I'll just continue. Now, Lords, if your Lords, I'm grateful. Now, please just just before the lunch break, I had moved to the BIFR order. Your Lordship recalls. Page 100, main paper book. Clause 8.
Yes, 22A order.
Correct? Your Lordship has seen that with a reference to section 22A. Now, may I just request you to have asked the court master to just hand over the Sikh Industrial Companies Act. Just have a look at 22A.
We have got number of orders on this. Proceedings may go on, but final orders may not be passed. Please to move those applications. This doesn't have to amend.
The Lordships have section 22 capital A.
Yes.
Direction not to dispose of assets. The board may, if it is of the opinion that any direction is necessary in the interest of Sikh Industrial Company or creditors or shareholders or in the public interest by order in writing, direct the Sikh Industrial Company not to dispose of, except with the consent of the board, any of its assets during the period of preparation and consideration of the scheme under section 18 and during the period beginning with the recording of the opinion by the board for winding up of the company under subsection 1 of section 20 and upon commencement of the proceedings relating to the winding up before the concerned High Court. So this is the direction restraining them in clause 7 at page 100, that you will not dispose of any fixed or current assets of the company without the permission and consent of the secured creditors and the board. Now please see what they do. Page 163. A7. The Lordships have A7.
Supplemental.
Yes. So now this is styled as a supplemental trademark agreement. Please see the date, 15th July 2008, between Fort Gloucester Industries Limited and Gloucester Cables Limited. Then number 1, first party is the registered proprietor of the trademark Gloucester under a registration number so-and-so. By an agreement of 29 July 2004, the first party had granted the second party an exclusive, non-transferable license. Now, please go to clause 5 on recital 5 on page 164. The first party is prohibited from selling the trademark at present in view of the order of 10 September 2001 passed by BIFR. Your Lordship has that? So it records that. Then please see the second party, they've asked for an assignment. Now, therefore, please see clause 1. The first party hereby agrees to assign the trademark in favor of the second party for a consideration of 10 lakhs, which shall be paid by the second party at the time of execution of the agreement, the receipt whereof the first party hereby admits and acknowledges, provided, however, that the assignment shall become effective without any further act or deed only after the above-mentioned order of 10th of September 2001 of BIFR is vacated and or discharged or the first party is wound up under the provisions of the Companies Act, whichever is earlier.
Now, what is the proof of this payment? Was any bank document?
Yeah, so now, my lords, in the supplemental documents which they have filed for the first time over here, they have placed certain documents, etc., on record to show that there were, you see this resolutions, etc., which are passed, and certain bank transfer amounts, etc. So that they are seeking to introduce that, to which we object, because it was not there before the NCLT, it was not the NCLAT. But be that as it may, as I am going to show your Lordship, this document supposedly introduced, made on 15 July 2008 was also withheld from BIFR at the relevant time. So please go to the BIFR order at page 188. This is dated 16/3, no? 16/3/2012, Annex A9. Page 188. Your Lordships have page 188?
Yes.
Yeah, so just, I'm only on the first page, 188, pointing out the date, 16/3/2012. Then you have the quorum. Then various representatives are given who were present. And now for our purposes, please go across to page 190, para 2.3. Third or fourth line. So there were allegations against having removed certain assets, etc. And now please see what they say in the context of trademark. The third line, 2.3. The representative added that, however, the applicant Pegasus did not reply or filed a rejoinder to that. That means that they are satisfied. The representative of the company further submitted that there is no violation of the directions of the board. The applicant is well aware of the fact that the trademark has been licensed to another company from 2004. The right to use the trademark has been given to the other company, Gloucester Cables Limited, and they are spending money for the development of the trademark. The representative submitted that as regards the allegation of violation of 22A is concerned, there is no violation. So this is what the BIFR records. As far as we can make out from the record, there is no disclosure of any supplemental agreement, etc., insofar as BIFR is concerned. Now, please just go 2 pages or 4 pages later.
The violation was in the context of some land sale.
Yes, that was a separate issue, Manoj, that we are not concerned with. But 22A is not, because what we are saying is they couldn't have done it at that point of time. This particular assignment, that it will take effect on, and your Lordship recalls the assignment, the terms of the assignment. Yeah, it does. So the allegation, my lords, of course, was also on trademark. Your Lordship sees that. The allegation, if your Lordship just sees, para 2.2, just go to the earlier page, 189. In today's hearing, the learned advocate representing Pegasus, so Pegasus, my lords, was the asset reconstruction company, submitted that the SIG company has assigned its valuable assets, the trademark, to another company in violation.
Which page?
Page 189.
10 crores. So this is not the 2008 agreement.
Yes.
10 crores.
May I just place this? In today's hearing, the learned advocate representing the applicant Pegasus submitted that the SIG company has assigned its valuable assets, the trademark, to another company in violation of rules, and the company has created charge for loan of rupees 10 crores. The company has not made any disclosure in this regard. The learned advocate submitted that he had moved an MA for orders of the board on the illegal sale of land by the company in violation of directions of the board, and also on the charge hypothecation of the trademark Gloucester, it should be.
And for 22A, he said there's no violation. Company's counsel said there's no
The
violation.
company's counsel said in the context of 22A that there is no violation by us.
Because
And-
they put a clause saying it will come into effect only after.
But there's no disclosure. But he says that there is a license, which is the extant license which was there.
It is a pre
Yeah.
22A.
Yeah, but I mean, there's obviously clearly a lack of candor, assuming that this agreement was there. I don't believe this agreement was there before them at all.
No, but that doesn't follow. In fact, shows agreement was there. Your case was that there is a violation of.
No, that is my case today.
No, this is a 2012 order.
Yes.
This is a, see,
Yes.
this order,
Yes.
if it is being debated,
Right.
that there is an assignment.
Hmm.
It shows this much, that while on the one hand, there may have been a 22A violation.
Hmm.
The fact that there was an assignment is reflected in a.
No, that's another assignment, bro. This may not be this 10 crores.
This is the 2004 loan agreement.
This is something else. This 10 crores. Ours is a 10 lakh. Nothing. So this is something else which they are talking about. That's why we feel that this is all completely got up.
No, there are two separate things.
Yes, that's true.
Assigned its valuable asset, the trademark, to another company,
Yes.
and the company has created charge for loan. That is,
I don't know, Manoj. Manoj, I don't want to speculate on this. In any case, Manoj, we go by the objective orders. There is clearly a direction under section 22(1). You could not. They tried this particular so-called supplementary agreement, which says to take into effect as.
your point which they will have to answer as is the registration point, which is clearly post CARP.
Yes.
Without the involvement of the RP.
Yeah.
According to you, registration is mandatory.
Yeah.
And doesn't take effect.
Yeah.
So notwithstanding the validity of 2008 supplementary agreement
Yeah.
or the 2017
Yeah.
draft assignment deed,
Yeah.
the fact that the registration happened
Yeah.
only in 2019
Yeah.
without the AGs or blessings of the RP
Right.
negates
Yeah. That's the section 14.
14(1)B.
That's right. That's the